Hello everyone, welcome to another session of Bangalore Value Association along with IOB Registered Valuer Foundation. We at Bangalore Value Association believe in providing timely education and alignment of all the valuers, and this is one such webinar. Before we start the webinar today, I would also like to apprise all the participants about our upcoming workshop on 22nd and 23rd of August, Amrit Kal of Valuation, in which some complicated valuation methodology will be solved by our key technician and speakers. So I urge all the participants to quickly register for the upcoming workshop. With this, I would ask Mr. Ravichandran to introduce the key speakers for today's session. Ravichandran ji.
You're on mute, Mr. Ravichandran.
Yeah, I'm sorry. We welcome you to webinar number 121. The topic on untapped areas of practice for valuers across Companies Act, SEBI, FEMA, IBC, and other corporate laws. We have two distinguished speakers today. One, Mr. Venkata Subbarao, who is an experienced professional with over 22 years of expertise in corporate laws, insolvency, valuation, legal advisory, and business setup. He is a practicing company secretary and insolvency professional and a registered valuer, SFA. He is currently serves as an independent director on the boards of two companies and actively involved in professional development, regularly speaking at the ICICI events and academic institutions. He also holds leadership roles as the vice president of the Bangalore Valuer Association and is a former chairman of ICICI Bangalore chapter. We welcome you, Mr. Subbarao. And we also have the next speaker, Madam Shilpa Kiran. Shilpa Kiran is a practicing company secretary with 22 years of experience in corporate compliance, valuation, and insolvency. She is a registered valuer, insolvency professional, and an independent director of two corporate boards, a founder and past president of the Bangalore Valuer Association. She has issued over 100 valuation reports and regularly appears before NCLT. She is also a sought-after speaker on valuation, company law, FEMA, and IBC. We welcome you, Shilpa Kiran. We welcome you, both of you. Over to you, sir.
Good morning, everyone.
Thank you, sir. Thank you very much for nice introduction. And before starting the session, Happy Raksha Bandhan to everyone on the occasion of Happy Raksha Bandhan. Like how the brother and the sister help each other, the Bangalore Valuer Association helps the valuers community in giving webinars or upgrading the skills and knowledge. And as part of this webinar, we are going to discuss untapped areas of practice for valuers across Companies Act, SEBI, FEMA, IBC, and other corporate laws. First of all, I thank Bangalore Valuer Association for giving this opportunity. Today, I am going to discuss on Companies Act and IBC, and along Shilpa Kiran is going to discuss on SEBI, FEMA, and other corporate laws. Yes, as you know that we are the registered valuer recognized in the year 2017-18, and initially it was recognized as a registered valuer under Companies Act and IBC. Like there was a very minimal role in SEBI, in other laws also. But in Companies Act and IBC, it was like in section 247 that any valuation has to be issued by the registered valuer. And we know that many cases where we issue the valuation report in Companies Act, where the company is going for further issue of shares, and where the company is going for any merger or demerger, or if any reduction of share capital, and if any buyback. These are the normal scenarios where we are going to issue. And today we are not going to discuss those areas because we have been issuing the valuation report in those areas. And again, if you come to IBC, again, we have to, as a valuer, once the RP appoints as a registered valuer, we have to give the fair value and liquidation value. And today we are going to discuss, apart from the liquidation value and fair value, what are the other areas where we have to give the value, that we are going to discuss. And I'm going to start with the first issue of securities for consideration other than cash. And we have a chapter and we have a section 42 and 62 in the Companies Act, where the securities, the shares can be issued consideration for other than cash. And we have like a few scenarios where the person is going to transfer, the entity or person is going to transfer land and building or leasehold rights, and we can issue the shares other than cash. And even intangible assets or financial assets. Like these are the few scenarios which we know that, okay, the physical asset is coming, whether it is a land and building, plant and machinery, or an intangible asset, or a software, it is coming, and there is no issue. We can issue the shares and we can value those assets of those movable property or immovable property, and we can issue the shares. But over few years, the interpretation, in case where company has taken loan, the conversion of loan into equity. In recent past, okay, we have seen in few scenarios, the companies are the company issued loan and they want to convert the shares. Here we have two scenarios. Like when, as per Companies Act, whenever you are taking any loan from the directors, we need to enter into an agreement, loan agreement. And again, we need to pass a special resolution and we need to file MGT 14 with ROC. This is the normal scenario. Many companies will follow this one, like where they enter into loan agreement, they pass a special resolution, they file MGT 14 with ROC. And if you are again converting that loan into equity, there is no issue, because already you have intimated and we have taken approval from the members and we are going to convert into the shares. But we have a scenario 2 where there is no existing agreement. In few private limited companies, what happens, the directors will give the loan or they will fund amount, they will transfer the amount for day-to-day activities, and they think that, okay, we will pay back the amount in due course, maybe 2-3 months. Because of, again, cash problems, due to so many issues, they could not transfer the money back to the director. Then again, after 3-4 years, the money will be accumulated, maybe 3 crores, 10 crores. And again, the company may be doing good. The company share price may be more. That time, the director want to convert this loan into equity. For this, again, there may be a members, okay, they put objection. Where is the agreement loan and how the loan has been recognized? Who has given the value? Because the directors or members may be joined recently and the loan has been given so many years, like 4 to 5 years or 10 years. How to identify the loan? Who will identify? Yes, we know the share price, that is 100 rupees. But what about loan? There is no agreement, but there is no MGT 14 and there is no resolution passed by the members. In this scenario, now we have the opportunity. As a valuer, we need to value the loan. And again, there are interpretation issues, like why should we value the loan? Because there is already the amount is showing in the balance sheet. Yes, amount is showing in the balance sheet. They may treat as a loan or they may treat as a debt, or there is no, okay, maybe they may pay after 2-3 years, 2-3 months, like that. But wherever, when the company is going to issue the loan, the shares for consideration other than cash, and the interpretation is you need to get the valuation for the loan also, the valuation for the debt also. Maybe sometimes we can include even interest also we can include. If the members or directors are agrees, we can calculate the interest and we can give the report. Because maybe the balance sheet showing for 31st March some 4 crores loan is there, but you are issuing the shares in the month of August, then there is no proper documentation how this loan has been recognized. In these cases, what we can do, like as a valuer, we have to give the loan valuation also, that is debt valuation also, for consideration other than cash. And we have here the what if the company does not have such agreement. Just I prepared one small presentation. the flow chart. Here in this case, okay, the company requests the lender to accept the securities in lieu of loan. Actually, what is the process? I am just covering the Companies Act. Being a company secretary, I am covering the Companies Act also. Here, the company has to request the lender to accept the securities in lieu of loan. And if the lender accepts the request, the company can crystallize the outstanding loan amount. How the crystallization will be happen? That will be happen through valuation report and obtain a valuation report from a registered valuer as required under section rule 13.2.1 of company share capital and debenture rules. Like when you are converting a land and building, or when you are converting a patent rights, or when you are converting any software, you need to get the value of those software. The same way you need to get the valuation report for this loan. Obtain the valuation report to decide the issue price. That means here we need to give two valuation reports. One is to get the share price as enterprise valuation, DCF valuation we need to give. And again, we need to give for the loan valuation also. Yes, as on 31st August or 15th September, this much is the loan and this can be converted.
Subbarao, there is some technical glitch. Sorry to interrupt.
Yes,
The
please.
slides are not moving. We are only seeing the welcome screen.
Oh, sorry.
If you want, you can make it to slideshow mode.
Yeah.
What sir is giving overview of the things. Then I
No,
thought
sorry.
slides is good.
Yeah.
I was
You are able to
thinking
see
like
now?
that. Then when
You are able-
he was...
Then I thought
You are able
5
to see
7
now?
minutes he will give the intro about all the things he will cover. Then
No, you are able to see that?
presently,
flow
we are
chart?
only seeing Zoom.
No, Subbarao.
No, okay, one.
We
I'll
are
stop
seeing
this.
Zoom.
I'll see the entire screen, I will share it. You are able to see now, Shilpa,
Ah,
the flow chart?
yes, sir.
Can you see the flow chart now?
We can see? Yes, we can
Yeah.
see.
Okay, thank you. Sorry, yes. Yeah, this is one, okay, my first slide, okay, issue of securities for consideration other than cash. And just I was explaining the way in which scenarios the securities will be issued. Like we have land and building leasehold rights where the company or the person is transferring to the company, entity is transferring, then we can issue the shares. Where in intangible assets or financial assets and technical know-how. This we know usually, okay, where we have to value the technical know and we have to value the share price. And today we are going to discussion conversion of loan into equity. And as I discussed, like we have two scenarios where there is a loan agreement. Already the loan agreement is there. Through loan agreement, the person, the director is transferring the money. Then we need to pass a special resolution. We need to file MGT 14 with ROC. In these cases, we don't have any issue. We can obtain the valuation report for the share price and we can convert the loan into equity because it has been already filed with ROC. But we are going to discuss today where there is no existing agreement. As I said, in few scenarios, the directors will be transferred for day-to-day transaction, day-to-day activities, the amount, and they don't enter into the agreement. Even they don't file any document with ROC like MGT 14, they don't take any approval for special resolution. In these scenarios, what will happen after 3-4 years, once the company goes into a good position, then okay, everybody will come and the share price is increasing. That time when you are converting loan into equity, then every question will come. Where is the agreement? And where is the MGT 14? And who has passed this resolution? There is no special resolution. In these scenarios, in these cases, what we have to do? We have to do the loan valuation also. And many professionals, okay, whenever we get inquiry about the conversion of loan into equity, as a company secretary, first we will ask whether you have any loan agreement. If there is there is agreement and there is MGT 14, then there is no issue for us also to issue the report. Then when there is no loan agreement, there is no MGT 14 filed, then even they don't have any clue how to determine this loan or debt. then what we suggest is like go for this loan or debt valuation also. Then you can convert that into equity. That's what I'm
Subbarao,
giving.
here I have a difference of opinion.
Yes, please.
In the earlier V2 PAS3, sorry, V3 earlier version, not the new version, the earlier version of PAS3 had this in V2, consideration other than cash, conversion of loan. That was there in V2. But now the recent PAS3, whatever we are filing now in V3, that is not, that specifically, that was a point at that time. Okay, consideration other than cash, we have an option to take conversion from loan. But now in the existing PAS3, we do not have all of that. And more so, the question what we have is what is actually there in valuing a debt? A debt is a debt. Maximum you can have interest accrued. It's a simple calculation. So there are certain interpretations in the company secretaries that, this valuation is actually not mandatory. And it's just a matter of good corporate governance that this report is taken. There is nothing to value. It's just a cash equivalent only.
See, the cash equivalent to the.
Yeah, sir, I am telling, if we keep doing this, if there is no agreement has been signed or MGT 14 has not been filed, I also get some of the queries where we don't have 3-4 years directors have taken, they have preference shares also which they want to convert, but the agreement was not like that. If we keep correcting those things, these things will more accrue. The company always take loan, but they want to convert and they have not filed the agreement also, they have not made the agreement. In this type of situation, it is very difficult to value as agreements are not in place. It is my always a query and confusion. Yeah.
See, then how you do, ma'am? Like if you don't have the agreement, like how you are determining? Okay, even the company is determining this loan.
In fact,
as
what we
also told, ki loan is loan. If they sometimes it happens, it is like interest. They are not charging. They are waiving the interest in the balance sheet. Also, it is written. It is interest-free loan. We can tell them if the time is there, ki you can do a loan agreement backdated, that kind of thing.
Ma'am, that is the reason. Okay, loan backdated. Okay, even if you see in Karnataka, we cannot get any stamp. Okay, backdated stamp and all. But even the scenarios where it will come, two scenarios. One, we have filed, once you file the PAS 3, or okay, once you file that MGT 14 and PAS 3, we know that okay, it's a straight through PAS, like okay, approval. There is no involvement of ROC. But where the directors, okay, sometimes the new directors or the new members, they will question like how you are determining this loan. For example, the existing director who has given the loan, they may ask that, okay, like we need that interest also. Then who will determine that interest? Whether it is 6%, 8%, and 10%. There are disputes. Okay, yes, you have given the loan. Where is the proof that you have given the loan? Sometimes, yes, we can take it that all bank statements last 3 to 4 years as a bank, we can see that amount has been given. And then what about the interest calculation? The director is saying that there is a dispute. I want to get that interest amount as a securities. In these scenarios where okay, the question has been raised by ROC in few cases, how it has been determined. And even that's what, as I said, okay, Rule 13 says that the valuation of debt also is required.
Subbarao, are we valuing the debt? Are we valuing the equity price there? Because suppose we have 1 crore as debt. Okay, whether accumulated interest or not, that's one issue. But whether the conversion is happening at 10 rupees or 15 rupees, is that the issue, or is the valuing the financial asset? That's the issue then.
Sir, we are valuing both, sir. We are valuing the debt as well as the share price. The share price may be 100 rupees or 200 rupees. And again, the valuation of debt also, like whether it is 2 crores, 3 crores with interest or without interest, that is depending upon the company.
Okay, then I'll tell you another problem. Suppose when bank gives a loan, there's the inherent right for them to convert into equity.
Correct.
So are we doing all this process at the time also?
Sir, if there is again, see, when the bank is given, there is a again, okay, you must be having CAG1.
No, there is a charge creation is different. We are talking about this valuation purpose, no?
There is an agreement will be there in that case.
Right. You see, all loan agreements will have this standard clause.
Correct. Correct.
So are we following all this process for that bank loans also then? In addition to this CHG1? CHG1 is a different because
at least you have that the loan CHG1 is there, you have agreement with the bank, but where in few scenarios there is no agreement. If you see in the startup companies, few private limited companies, okay, there is no loan, okay, the keep on the director transferring 30 lakhs, 40 lakhs, 50 lakhs, and there is no even board approval or members approval. Those scenarios, okay, the ROC is sending for resubmission.
no, but you didn't answer my question.
So the
I have
CHG1
a few points to share, sir. Basically, any loan agreement, what we have observed is the conversion price is actually not agreed. We just have a debt and there is a sanction letter and there is an agreement for conversion. So in this scenario, according to me, debt will not be valued because debt stands as it is in the books, but the conversion price or the equity valuation will be done by a registered valuer. Accordingly, bank has to agree for conversion. This is my submission.
No, it's not that way.
Ravishankar sir, one minute.
The conversion happens in case of a bank loan when the bank is not able to repay the loan. Okay.
Correct.
So which
Company is
means
not
that
able
share
to
value is always less than 10. So that's why the conversion always happens at 10 only.
Sir, it is not that like how it is
Right.
determined, okay, less than 10 when the company is having a good business and when company is going, okay, like DCF valuation, how it will come the 10 rupees?
No, when company is doing well, then there's no conversion of debt into equity at all. The bank will be regular, company will be regular in paying the debt. So the conversion clause will never be activated.
Sir, it is
Ravishankar,
okay. Yes, sir.
in your case, I think he has addressed in the beginning itself. What he says is that such clauses are there. There is an agreement. You have to file an MGT 14 in the beginning itself, so that that conversion automatically takes place. That in such situation, if there is he is talking about only the agreements are not there.
No, Shilpa, what I was saying is that initially when I asked this specific question, he said when there is a bank loan, we are filing CHG1, which is a charge creation.
No,
Charge
not
creation is a
that.
different problem.
Prior to that, he said that if there is an agreement, you have that you have to file it with that agreement. You have to file it with the ROC MGT 14. That is where the documents have to be filed.
But we are
So-
not. I never did it. But
No.
people doing
Sir,
every
if you
bank
see
loan? Are we doing
technically-
CHG1 plus MGT 14?
Technically, if there is a clause like that, that you have to file it.
Correct. Sir,
So-
if you have a clause, okay, like you are going to convert into equity, then you need to take the members' approval also by passing a special resolution. And you have to file with ROC.
Okay.
See, that's what, okay, the terms of such conversions are already included in the loan agreement or debenture trust deed, and the agreement has been approved by shareholders by a special resolution at the time of issue of acceptance.
Can proceed, Subbarao. This
Yes.
is really a debatable topic. Thankfully, banks are not, ticking
Banks
or.
will not be, madam. No, banks will not be. ROC will be. We are worried about ROC.
You are able to see my screen, the flow chart?
Yes.
Right.
Yeah. Yes, and we have to hold a general meeting to approve the issue of securities on a preferential issue or private basis. And here the crux is like we need to get the two valuation report, the valuation of loan and the valuation of equity. Yes, there are different opinions and interpretations will be there, but as a corporate governance, or if tomorrow, like in after 2-3 years, if any due diligence comes or company is going to IPO, at least we will have such a documentation as the loan has been recognized and it has been converted. Okay, unless asking go for compounding or adjudication, at least we will follow the procedure, because initially they have not done the loan agreement and filing with ROC. This is the one scenario. Like in a brief, the scenario 1 and scenario 2, where there is existing agreement and filed with ROC, you can follow 62(3), and we need to determine the fair value of equity shares. In scenario 2, there is no existing agreement, we need to follow 62(1)(c). Even when you are filing in a pass 3 with ROC, you need to select in scenario 2 62(1)(c). You cannot follow 62(3). To determine the fair value of equity shares, and again to determine the value of unsecured loan that shall be converted into equity. You are able to see my screen, CHG9, Shilpa?
Yeah.
Yes.
Yes, this is one untapped area. Yes, there are interpretations will be there. Okay, whether to take our loan for good corporate governance purpose or for due diligence to avoid all those adjudication compounding. It is better to give that loan also. Even the companies also, okay, the other directors also requested to value the loan. At least, okay, the other directors feels that there is a loan and we are converting into equity. And we have the second scenario, like where issuance of secure debentures, that is non-convertible debentures, and filing CSG 9 with ROC. And as you know that now all documents are approving at MCA in the CPC. Now only few forms are approving by ROC, like state-wise, like Karnataka or Hyderabad. Those in one of the document is CSG 9. It is not going to Manesar. It is going to be approved in the respect to ROC CSG 9, and also we have on one more document like IMC 28 also will be approved. This is the one document CSG 9. You need to file with ROC where the company issued secure debentures and non-convertible debentures. If the company is raising any form of money like 100 crores, 200 crores, within 30 days we have to file with ROC. In like whatever practice, what we have been doing so many years, whenever we are filing CSG 9, we will attach the resolution passed in the board and members, and also we attach the debenture trustee agreement or any other agreements entered with the debenture trustee, we file it. But in last few months or few years, the ROC is requesting to attach the valuation report also. And even we have few cases where the ROC sent the CSG 9 for resubmission to attach the valuation report. Not only a valuation report, and also sometimes the ROC requesting to give a certificate from the auditor, whatever the assets are secured, it is okay, the coverage ratio is there, the amount can be paid. And even in few scenarios, okay, we went to ROC and requested, like we are getting, okay, the new requirement of attaching valuation report CSG 9, we have not seen in the past. So many years we have not seen. Even CSG 1 also, once you file it, the certificate will be generated. It is a straight through password. Then, but whereas CSG 9, it is going to ROC and they are requesting.
I have a query here. Sir,
Yes,
in
please.
case of secured debenture, it is like a convertible, non-convertible. In case of non-convertible debenture, there is no requirement of obtaining a valuation report.
Yeah, that's what it is not required.
But some people are asking these days, maybe
Yes.
for the ROC reason.
Correct. People are asking, that's what I'm going to discuss now. The ROC is requesting to attach valuation report and also asset coverage ratio also. And he is mentioning or valuation report or asset coverage ratio. Even for asset coverage ratio, the chartered accountant or statutory auditor has to give, again, they have to value the assets. But okay, they are specifically asking the valuation report. I give that the ROC, even we met ROC, what is the reason, sir, you are giving? Okay, it is a burden to the company also getting valuation report where they are issuing 100 crores, 200 crores by giving the security of land, for example, like 50, 60 acres of land, and we need to get at least 3 to 4 lakhs to pay that valuation report.
Bro, you
And
use the word land and building. So in case land and building, plant and machinery, and we have this current assets. Normally, hypothecation also could be there of the current assets.
Yes,
so
the trade receivables
who will
be there.
consolidate?
I'll come to that one. The next slide, that one. Yes. Okay. The land and building is there. Okay. Why I'm telling, okay, in few scenarios, what is happening, even the company thinks that, okay, it's a burden. Okay. Like 3 to 4 lakhs, we have to pay the valuation report. Again, we have to attach. Anyhow, the debenture trustee itself is accepted and he is signing the CSG 9. What is your problem? Because when you are filing CSG 9, it has to be signed by the debenture trustee, it has to be signed by the company, and it has to be certified by the company secretary, the professional. And why you need the valuation report? But they have given the examples in few states, like in West Bengal, Kolkata, in other state, Maharashtra, Mumbai, where the company issued NCDs and the company has defaulted and they don't have, okay, the money. When they go and see that, okay, there is no asset at all. When at the time of filing CAG9, they mentioned that these debentures are secured by this land and building or trade receivables or cash. But when it comes to realization, there are no assets. Even we have seen in the Karvi case, Karvi also has issued NCD, and at the time of realization, okay, many retired people has invested, okay, for the sake of 10%, 12% interest, and the company goes into default, okay, there is no assets at all. And they have given these, they quoted these type of examples. This is the reason we need valuation report. And also there is a clause in the Companies Act, the ROC should satisfy with the asset, the security. And the ROC is saying, how I am satisfying? Can I satisfy with the debenture trustee agreement? Or can I satisfy with the board resolution? Or can I satisfy with only the whatever board resolution passed or general meeting passed? That is the reason I am asking this valuation of asset. You are giving 200 crores, 300 crores NCD, but where is the value? And you have only 1 lakh paid up share capital, and you are entering an agreement with landlords, okay, like jointly. There is no value in the company. And you are issuing 200 crores, 300 crores at the time of again realization, there are no issues. And who is responsible that time? We went to again High Court. The ROC officials went to, okay, they questioned, how did you approve the CAG9? This is the reason they in the past, okay, so many months, they are asking to attach the valuation report and the asset coverage ratio also. And also they are asking, okay, a declaration from the debenture trustee also. And we know that debenture trustee, with due respect to debenture trustees, and okay, even they give services for sake of 20,000, 30,000 rupees per annum. The competition, whatever. But when you issue 200 crores, do you think that debenture trustees will come and protect your rights as a debenture holders? Do they have that much the infrastructure? And are we paying that much? Even as insolvency professional, I have seen in a few cases, the debenture trustee itself will not participate in the COC meeting. And they will say that, sir, we don't have any this one, okay, we just entered agreement, that's all. And they are paying only 15,000 rupees per annum. Can debenture holders expect that the debenture trustees will realize my money? In practical scenarios, it will happen. These are all the questions raised and also discussed among the statutory authorities.
But Subbarao, here I have a point.
Yes.
You're telling that, definitely all of us know that debentures can be issued in tranches, and then, valuation is required once.
Yes.
But what is the date? Because now only documents
Yeah,
are like
that I will cover. I will cover that one. Next is that is only coming. Okay. See the background of, because see, though even when we are issuing the valuation report also, okay, that so many professional asked, okay, sir, this is a one more burden for a company, okay, getting the valuation report, especially, okay, trade receivables, cash and bank balances, stock, we can get it from SFA valuer, whereas again, land and building will be there, okay, it's a cost of 200, 300 crores, and we need to pay 3 to 4 lakhs, it is a burden. Okay, and yes, convincing the client or okay, the company is very difficult, but the ROC also it is saying that yes, we have a few scenarios where the debenture holders are lost entire money, and as a registry, I need to satisfy to register this CAG9, and you are not issuing okay just 1 crore, 2 crores, you are issuing 100 crores. Even 1 crore, 2 crores has a more money, big money. We cannot compare 1 crore and 200 crores. I have to protect the debenture holders, and they don't have any rights in the company. It is a non-convertible debentures.
Okay, the valuation report required is a land and building or SFA?
That I will cover. That also I will cover. Yes. Here, a role of registered values in secured debentures. As you know that Section 247 again, Companies Act covers. Okay, like we need to give the fair market value, and only the registered value is eligible. And what is the purpose? Okay, it's a transparency and regulatory compliance purpose. The valuation report provided by registered value helps to ensure regulatory compliance. Tomorrow, the ROC can say that, okay, see, I have the valuation report, and those assets are covered with this valuation report. And there is a confidence to the investors also. When I am going to issue 200 crores, as an investor, I want to see the valuation of the company, valuation of the land is there or not. Just like that, I can't say that 50 acres land in Devanahalli or 50 acres land in Hyderabad, I can say that 200 crores. Who is valuing that? It will get that confidence to the investors and debenture trustees also. Tomorrow it is a protect to the debenture trustees because they are going to sign the CHG9. They are entering into the debenture trustee agreement, and it is all good for them also. Yes, here we need to get the valuation report, and we will cover, okay, like in different scenarios, how we need to get the valuation report, whether it is a land and building, plant and machinery. Okay, first, the report will be requested after submission, after form submitted for resubmission. That is in one scenario, okay, where few companies, they are coming to valuation. 99% companies will not come before filing CHG9. We need valuation report because it is a gray area. Let us file the CHG9. If ROC asks, even they don't know that, because in the past so many years, without filing valuation report, they are approving. And as a usual practice, we will file the CHG9 without filing a valuation report. But in few cases, they are sending for resubmission. In that case, we need to get the valuation report. And here, we need to identify the assets. First of all, we need to see the CHG9. Once you get any valuation report requirement from the client, first we need to see the CHG9, because in the CHG9, there is a tick mark, okay, like what assets you have given. The movable assets, then cash and bank balances, any intangible assets, all those things, the tick marks, whatever assets we are giving, we have to see that one. And as well as we also have to see the agreement entered and what assets are covering: land and building, plant and machinery, trade receivables, even trade receivables in the future also. In one case, ROC requested, in one agreement, they are saying trade receivables as an existing trade receivables and future trade receivables. How future trade receivables I can determine? If the company is not going to have any sales, what is the future trade receivables? Future cash. This is the agreement. With this agreement, I need to sign, I need to approve the CHG9. What is meant by trade future receivables future? Cash future cash. Now the companies are going to lose, okay, that zero value will be there. Where is you are again giving future trade receivables? Even we have seen one company, they have given trade receivables are zero, and they are saying trade receivables futures are secured. Okay. Yes, these are the like identifying the assets are important. If the company is having land and building, and they are giving as a security, and we need to get the valuation report from the land and building valuer. Okay. Because usually what happens in the NCD case or CHG9 case or usual practice, they will give all the assets.
Subbarao,
Yes,
small correction.
Yes.
See, there are fixed assets, there are mobile assets. Mobile assets include your inventory and receivables, cash balance. So
Yes,
when the security is given, fixed asset as of today, mobile as current assets are which the company is operating. So they move up and down, up and down. Suppose you say there are receivables 100 crores, suppose you are issuing debentures against the receivables.
Yes.
Say 10 crores are the receivables. Now that doesn't mean that 10 crores will be there till the debentures redeemed.
Yes, sir.
The 10 crores will be recovered today and new receivables will come tomorrow. Then again, that will be received. So,
Correct.
so if somebody is asking you, what is the future receivable? That's because it's a moving asset, the company is permitted to operate them because the inventory will also go up and down. Whereas fixed asset is supposed to be there. So somebody is saying that what is the future receivable means there's no the concept itself is not that way.
In their practical scenarios where the company defaulted, where companies are zero and they are going to give. Okay. Yes. In these cases, how we need to give the valuation report as a registered SFA, because usually the company will approach SFA person immediately to give this valuation report because they are going to give the trade receivables, cash and bank balances in all other assets. In that case, if the company has given the land and building or plant and machinery as a SFA valuer, we need to get the land and building valuation report and also the plant and machinery report, and we need to attach as annexure 1 and 2, and we need to give the total. Yes, it is the current assets, non-current assets, the value of the assets are this much we need to give. This is the one scenario. If the company has not given any, like company is not having any non-current assets like land and building, plant and machinery, usually you give like a inventory, stock or trade receivables, cash and bank balances that you can calculate easily, that you can give yourself. And here we need not to follow any DCF method because we are giving the assets value the security they have given as assets, no DCF is applicable. And we need to appoint land and building valuer, plant and machinery valuers if the company has given security as immovable asset. And the one more issue, the date of valuation and report date. Here, if you say that corporate governance purpose or Companies Act compliance purpose, you need to obtain the valuation report before passing the board resolution, where the company is going for issue NCDs. For example, the company is going for today, 9th August, they are going for issue of NCD by passing a board resolution, and they want to conduct again EGM, to call EGM, then you need to obtain at least 5th August or 6th August, you need to obtain the valuation report. And they can place that, yes, this value is there and we are going to issue for NCD. But in most of the 90%, 95% scenarios where we get the request after it comes for resubmission, the CAG9 comes for resubmission. And in those scenarios, even I don't recommend, to do the backdated and all, like again, it is a wrong, or compliance purpose also wrong. And what we can give is, you can take the date of valuation as like 31st July or 15th, whatever, you can take the date of valuation. Report can be issued as on today also. Even the ROC is accepting, because they need to, they are not worrying about, whether you have issued the report today or before conducting the board meeting. They are worrying about only the valuation is, or securities coverage or covered or not. That is the reason here we can give even date of valuation, today's date also, it is okay, because they are satisfying as and today the assets are there. And even you may have conducted the board meeting or EGM 1 or 2 months back, and here the flexibility is there. ROC is not questioning here, you must be conducted this valuation before passing a board resolution. How can you give the report date today? How can you give this valuation? They are not questioning. Even in few scenarios, ROC accepted the valuation report even 1 year back. 2 years back also, sir, we have the valuation report and we got it for 400 crores, 500 crores. They are accepting. They are not questioning again as issue of shares. It should not be like 6 months old and all. But we have to attach the valuation report. There is no issue in the valuation date and the report date. Yes,
considering the paucity of time, can you expedite it? It's already 8:15.
Yes, that is one. And need to check any other charges. Again, at the time of issuing this report, again, we need to check any other charges are there. Because if already some NCD issuing, again, today they are going to issue one more NCD, then again, it will be covered, like the more value will be there. You need to check that index of charges, you can check. And again, need to value third-party assets if the security is given as a collateral. Even I have one scenario, I done the valuation recently, where the director has some shares in a listed company. It is a private company, but he is having a shares in some company, like example, a Wipro company or in a Biocon, he is having a shares. He has given as a pledge those Biocon shares for this NCD. And if you see that since it's a private limited company, the company is having no assets, nothing, as and it is only 2 months back incorporated. That is the reason he has given his own shares, his own listed company shares as a security. We have valued those third party, even it is not a company assets. We have valued those Biocon shares or listed company shares, and we have given the valuation report. And we have seen that the charge has been created for that securities, for that shares. And asset value should be covered for the value of issue of security debenture. When you are in so many cases from now onwards, because it has been started recently, now you can get as a valuer, you may get request, then you can ask all these questions and you can give the valuation report. You can give the report date as on today also, there is no issue.
What about the second charge? Supposing company has given a second charge or a pari passu charge, then
Yes.
what do you do? Should we consider? Should we not consider?
So that also we have to consider, sir. We have to consider. See, as on today, I'm selling. I am not worried about, he has given more than the charges, whatever, loan he has taken more. I am giving only the, as on today, this much is their value.
But when you say you have to disclose the charges, existing charge, if it is a second charge or a pari passu charge, then it will be difficult for us to ascertain whether there will be any probability of getting it encashed.
That we have to disclose it. Even I have disclosed that also. That's why I said we have to see the index of charges. You can disclose in the valuation report. because we don't know whether it is covering or not. That is the reason, okay, even asset valuation is there 300 crores. That is the reason ROC is asking coverage ratio. He is saying that, yes, you have 300 crores valuation. Where is your coverage? You already issued some 400 crores, 500 crores previously. Then where it is covering? That is why he is requesting coverage ratio also. And also he is requesting declaration from the debenture trustees also is requesting. Yes. Sir, we have one more untapped area, Ind AS 109, where here in the chartered accountants, okay, when they are finalizing the financial statements, they are requesting this type of valuation report. Even I am issuing, okay, for a few years this report, like where, for example, like two companies are there, like a holding company and subsidiary company. In few cases, the subsidiary company will be having a huge parcel of land or some assets are there. The holding company is taking the loan based on the subsidiary company's assets, the land or building or plant and machinery. Here in this case, what happens? The banks also, when you are giving a security, the bank interest rate may be 9%. If they are not giving the security, the interest may be 10%. In that case, what happens? This holding company is getting some benefit of 1%. If you see like a few lakhs of 30 lakhs, 40 lakhs, then there is no benefit, you cannot calculate. When the company, the holding company is taking a loan of 300 crores, 500 crores, 1000 crores, by pledging the assets of subsidiary companies, the 1% interest may come to even crores of rupees, 30 crores, 40 crores, change will be there. In these scenarios, the chartered accountant, the statutory auditor is requesting if there is any benefit availed by the holding company because of the subsidiary company property, that has to be given. Then it says Ind AS 109. It recognition of classification, measurement, impairment, and derecognition on financial instruments, where it covers of all financial assets and liabilities, even borrowings. I don't think so. Okay, all statutory auditors are requesting, but few statutories are requesting if very big amount is there, any benefit availed by taking loan, given subsidiary company has given charge of its property, then we need to identify as a valuer. And in few cases, we have seen that, okay, again, there are challenges here to calculate, because we have to see the bank interest rate. Again, we need to see that, again, whatever they entered agreement with the companies, and there is any clause because of this, okay, the repo rate, all these interest rates are changed or unchanged. We need to have a discussion with the bank as well as with the company. And if there is no benefit, we can give that stating, okay, the benefit is not available by the company, it is zero value. If there is a benefit, then we have to calculate the value and we should give the valuation report. Due to time passed, I'm going fast. There is a 109, okay, where this is untapped area where you may get some valuation reports. 109. Again, we have one more Ind AS 40, investment property. Here in few scenarios, like where the company is invested some land parcel, they may be 10 years back, 20 years back. Now the value will be seen, okay, it is a more value. Then, okay, if that they want to disclose in the financial reports, you can give this one. Again, you need to get the valuation report from the land and building valuer. And again, we need to attach as an annexer, and you can give that, okay, for financial disclosure purpose. Even in few requests, okay, from the statutory auditors, we got this one, and we have given the valuation report by obtaining the fair market value as on 31st March 25 or 31st March 24, and the statutory auditor is taking the fair value and he is disclosing in the financial statements. This is the Ind AS 40 requirement. This is coming newly, okay, by few statutory auditors are asking to disclose in the financial statements. Again, the untapped area, again, as I said, okay, like in 2017-18, when the valuation comes, like only we have Companies Act and as well as IBC has been recognized. But in past few years, when there is any litigation, the NCLT or ROC or official liquidator, arbitrator also is asking the valuation in the case of litigation, where, okay, like they want to distribute the assets, or there is a, like one director wants to exit, or they're removing one member, and he wanted to go, and they are valuing this. Okay, we are getting appointed by the NCLT, ROC, and official liquidator, arbitrator. In this, okay, this is again we have to estimate the economic value of the claims or damages. Okay, even it is a case-to-case basis. Okay, we have to always work closely with the legal counsel, and we have to maintain the independence and objectivity. And okay, again, when you are doing, again, we have to keep in mind that there will be a cross-examination, because even in few cases I have been cross-examined by arbitrator, and I went to arbitrator office, and they, how did you get this value? How did you receive this projections, 5 years projection? Who has given that? Did you get all the information? And we need to be prepared for cross-examination. Just I want to caution you, when you are doing a litigation valuation, you will be questioned. And again, when they are questioning again, okay, the arbitrator or the NCLT, they don't okay, they don't expect theory answers from you. They will say yes or no. You cannot say that, okay, again, valuation is a theory, valuation is art or science. They don't listen that. Even, for example, like they asked me a few questions, who has given these projections? Sir, projections we expected, like we only projected, or the directors has given, and as per valuation, we can see that last 10 years. Subbarao, you don't tell all those answers. You tell me only who has given this, yes or no. And again, we have to comply with all laws, because we have to do again various scenarios like DCF, then again market method, net asset value method. Please follow all those things in litigation valuation. These are untapped area. Now, because of all these disputes, we are getting, even official liquidator also is appointing the valuers, okay, whenever they are distributing the money to the stakeholders. Again, methodology and challenges. Yes, okay, like what is the claim? Okay, the dispute is because of business loss or IP infringement or partnership disputes or a fraud or damages. The dispute may be happen so many reasons. Then we need to do, okay, different approaches we have to follow. For example, like a partnership dispute, then they want to divide, then you have to follow the net asset value method. You cannot follow the DCF method, again 5 years projections, because the partners are dividing and we don't know whether they will reach or not. In that case, again, we have to do the both scenarios, net asset value method, DCF method. And again, like there is a IP infringement, then we have to follow the relief from royalty method. We cannot follow just net asset value method. And there is a fraud again. And how much fraud you have to value, then you have to do the forensic accounting, and again you have to see those valuations. And again, damages, because of, okay, like what happens in the few partnership cases where we have seen they are the partners, and again one partner is going again side, okay, he will start one more company with the same business, and the other partner don't know that, okay, like he's doing the same business. Because of that, okay, like again this he's not concentrating the existing business, he's concentrating in his own business, and there are damages. Then we need to calculate what is the like damages happened because of this opening a new branch without knowing where the existing partnership. And there are challenges. Yes, we have to take care of all those things, and we can give this litigation valuation. Again, coming to IBC valuation, and we know that as a registered valuer, and we have been appointed as a valuer by IRP and RP, and we will give the fair value and liquidation value. Even as per regulation, we have to give, as a valuer, we have to give the fair value and the liquidation value. And there are again so many challenges. We need to, the IRP or RP will appoint land and building valuer, again plant and machinery, SFA. Then other than land and building, plant and machinery, SFA valuer, we have to do all the calculations, whatever the assets. Here, the most important thing is, okay, in the recent past, like IBBI, okay, had a discussion. IBBI had a workshop on 24th July 2025. Shilpa, you are able to see the new amendments in IBC's slide?
Yes, this slide, yes, we can see.
Yeah. See, IBBI organized a workshop on enterprise valuation on 24th July 2025, and IBBI likely to issue a discussion paper on enterprise valuation. Till now, okay, as provision says that you have to give the fair value and liquidation value. Now IBBI is thinking that, okay, why don't the company issue the enterprise valuation also? Because you are giving only the fair value of assets, but there are other assets also there, like intangible assets, like goodwill brand. As a registered valuer, are we giving any goodwill brand? We are not doing any valuation for patents. even operational synergies, even purchased software, internally developed software, we are not doing value that. And even market position and strategic advantage, even distribution network like Danjo or something. For example, if some company goes, these startup companies, they have a distribution network. Are we doing that valuation? No, we are doing only physical assets or whatever they mention in the balance sheet, trade receivables, cash in bank balance or bank guarantee, stocks, inventory. Those things only we are touching. We are not doing any distribution network. And even customer data, the IBA is going to give on this one like enterprise valuation, and we have to consider those things. Even in sometimes the COC also is requesting the enterprise valuation through DCF. Again, there are challenges here. Who will give that projections? Whether RP will give, because we cannot take the board is suspended, and what RP is having a known this business, how can you give that? And whether COC will give the projections, and who validate this projection? All these questions are there, but in not 100% scenarios, at least where the company is ongoing company, it's an operational company, you can get it this one. And those projections can be validated through COC or through board and through RP. The three people can sit and they can validate. Just like that, you cannot give that, okay, because nowadays, you know that in IBC, there are so many parties. Okay, once the company comes into IBC, they want to buy the company because we will get very cheap rate. The valuation also will be cheap, and they will do only fair valuation, liquidation value, and they don't see any synergies. And there are a lot of people are ready to buy it. To stop those things and again to increase the value of the companies, IBA is going to come into the enterprise valuation. Again, we need to apply the income approach, DCF method, and again the market approach, if it is possible, market approach. Again, net asset value method, we have land and building, plant and machinery, we can get the net asset method. And again, challenges in the enterprise valuation, we have limited or unreliable financial data, because we know that as a valuer and especially, okay, the management is not cooperative, then we don't get any data there. And lack of visibility on future cash flows, because last 2 to 3 years the company is not doing anything, and again we don't know what is the resolution applicant prospectus or lack of visibility. And again, legal disputes on encumbrances on assets, and it will affect the realizable values. There are legal disputes. Again, how can, okay, the company already went into insolvency, then how can you estimate the income by a debt company, almost debt company? And again, enterprise valuation, again, you have tight timelines. And again, okay, as a process, you have to complete within 180 days. And whether this will be the income projections, or again, the beta you have to take, the company specific risk premium take, it is all challenges, questions. Like some person may take 5% growth, some person may take 2%, then entire value will be changing. And again, potential wide variations in valuation given by different valuers, and the two values will be there. If I am doing an enterprise valuation, it is 100 crores may come. If the other valuers may come like 40 crores, or it may come 200 crores, then COC in dilemma which valuation we have to accept. These are the few challenges in enterprise valuation, but the IBBA is going to come up with a paper on this, and okay, the discussions also will be requested from the valuers and from the stakeholders, how to do this enterprise evaluation, whether it will be a good practice or not. And even they know that there are challenges when it has come for discussion. So many questions has been raised. Yes, it is not for 100%. In all cases, we can get the enterprise valuation. At least few cases. For example, the startups, like we have Danjo, all those things, they don't have any land and building. Even if you see Byju's, the company under CARP, they don't have any physical assets, but the brand is there. Even somebody wants to use the brand, they have very good software is there, and they have a lot of material is there, like class 1 to again for till degree or PUC, there are so much is there that they can value. With this enterprise valuation, even there is no fair value, even if we can give like 0, at least you can give this valuation. And these are the few untapped areas, sum up in Companies Act, we have consideration other than cash, where loan agreement, and we have again the CHG 9, you may get request again. In few cases, like India is valuation 40 and 109, where we have to value. Again, we need to take the help of the land and building, plant and machinery valuer. And again, we have in IBC, the enterprise valuation. These are the new areas, untapped areas till now, but in future it may come and you can take this valuation assignment and we can do wonders. Thank you very much, and over to Shilpa.
Thank you, Subbarao.
I will stop my. Shilpa requested to give at 8:30. That's the reason I have given stopped at 8:30.
I think all of you can see my screen.
Yes.
ma'am.
Yes. So I welcome you all for this second part of this today's session, Untapped Areas of Practice for Valuers. Bangalore Valuers Association has been very close to me. You might have seen me in many of the sessions, almost all I can say. But then, yes, I am on a different seat today, and not as a host, not as a person introducing the speaker, but as a speaker itself. So, having taken this opportunity, I request each of the BVA members to please use the platform of BVA to showcase your expertise, your thoughts on valuation, and always BVA welcome its own members to showcase their valuation expertise. And I have one thought or one point on the session topic itself, untapped areas of practice for valuers, SEBI, FEMA, and other corporate laws. Like always we want, the focus is on law. But valuation, I feel, has got a very immense value or, demand beyond the law. We have seen this traditional, ESOP valuation, who is eligible, who is not eligible under Companies Act. Under, whenever grant is there, we have to take a valuation. And normally it is a registered valuer who gives at the times of the grant, and then accordingly accounting expense is done. Then we have this, whether whatever expense we have accounted in the Companies Act, whether it is permitted or not in the income tax, and then it goes on. And then we have all these, capital gains computation, wealth tax, purchase price allocation, goodwill, and the list is endless. But then I want to take the objective of this clause is to highlight that there are many other new avenues which are coming in. In fact, I'm not a pro in all of this, but then I want to share with all of you that recently the family houses are coming in, as an investors. Whenever we are checking with our startup value, companies as to who are the investors, they're telling one of the family house. This is a very common terminology we are using, family house. The family houses are now more interested into venturing into investing in startups or many other areas. So now in future, whenever any partition happens in these family houses, or we get to, value those family houses, we can have this, maybe one family member is a regular, art collector who is interested in more in art collection. Or say, for example, when I visited a recent museum, I was seeing a Raja Ravi Verma painting. So slightly it was torn here, there. But then I understand even if it is torn, the antiquity or the value of the art still remains unless and until the main portion or the face of the, the main portion of the art is not untouched. And having said this, say maybe some other family member is into digital art collection. Digital art is a very niche area. So we could get a chance in future. Suppose there is any company owning this, either that has come into CIRP as a part of IBC valuation, or it is going to fresh investments, and then we get a chance to value all these unique items of art pieces, either digital or virtual. Or one of the family member could be into, software, AI agent. Building an AI agent or owning an AI agent is a very new thing into this world. So I also want all the participants to unmute themselves and share whether they got a chance into any of these new areas of valuation. In fact, I can see this matrimonial disputes also these days, many startups are being started by family
Yes,
people.
we have done
So please
family
share your
valuation.
thoughts.
Yeah. In fact, we have done family valuation, family fund valuations. We have done valuation for this startup and early stage venture when pre-revenue companies, etc.
Sir, you went on mute. Dharmesh sir, you went on mute. No problem. Thanks sir, for sharing your thought. And this we have this ESG valuation also, carbon credit.
Shilpa, sorry to do. I'm Khazi Riazuddin. Good morning. Thank you. I also did one startup, or rather two startup valuation, and there was an opportunity for me to do art valuation. But I myself was not sure whether I'm the right person because I'm a valuer of SFA and art collection, and myself started looking for an art valuation because the client wanted me to help him locate the valuer of art pieces. Can we do it as a SFA?
Sir, we can take the help of an expert. But having said that, we as a SFA valuer should take all the precautions to ensure, like in your statutory audit, sir, you can rely on an expert, but then you will have to ensure that everything is also properly done. Monitoring, like.
But it's very challenging. It's very challenging to do a art valuation because every painting has got a different value.
Yes.
So and if you have to rely upon the art valuer expert, even he may go. How to give a discount, that would become very subjective of that. We can't just put his value onto art valuation report and sign it off.
So I request Ravishankar sir to give his thoughts since he has done recently one art valuation.
Recently, I had an opportunity to do one art valuation. And in fact, what Shilpa was saying, no, that the Raja Ravivarma painting, that was the art which has done the valuation. Now, as I said, I went to experts also. One of the experts said, sir, he's such a great man that I can't do valuation for him. So, that was the kind of a responses I got from them. But still, what I did was that it's the market comparison method only. So I almost did a 1 week research on that. And what are all the recent sales of Raja Ravivarma paintings only. I had to see one Raja Ravivarma movie, then Raja Ravivarma book I read it, then how his paintings are valued and all that. And very known paintings, what price they are valued at. So basically, what I could make out is that the valuation is based on the Raja Ravivarma was in the period of 1900. Okay, so but that time, there are big paints, famous paints, torn paints, and there are different kinds of paintings also they have done it. So all that we together, and then we give a value. And at the end of this, whatever value you do, whether the Companies Act valuation is equity share valuation, it is an opinion only. So based on the available data and the existing market value of other paintings, I could arrive at a proper value, which was accepted by the client also. But as I said again, if you are looking for an expert, most of the experts said that, sir, I can't value this. Because they were thinking that if I give a value of 1 rupee is a problem, 1 crore is a problem, 100 crores is another problem. So then they would simply disclaim, that's it.
In fact, my client imported some statues from Cambodia, and for that he wanted valuation report. I myself didn't know because never did I do it. So then I was wondering whether I'm the right person.
No, sir,
Anyhow,
you are the right person. You are the right person. There's no doubt about it. Because anybody else can do, you can definitely do it. Okay, anybody else can do it, you can definitely do it. It's only question of market comparison. Then you do a lot of research. How are the statues getting valued? And what is the market rate for that kind of statues? What is the value of Indian statues? So that you do some research and then arrive at an ultimate opinion. That's it.
Wonderful.
So similar to this, even for a jewelry valuation. But there we have the valuers of the wealth tax expert. We can get the database. But for art valuers to figure out who is doing art valuation, there is not much database available. So to find out an expert in becomes really an issue. Except that if you know somebody or if you go to an art gallery, you can figure out yes, who are the painters whose paintings are usually put up, and they can give you a reference.
Basically, auction houses help us, sir, because auction houses
houses help
has a panel of valuers But yes,
Yeah.
each of these areas, I'm so happy that each one of you have shared this kind of experience. This is what I say, untapped areas of valuation. Not that, definitely this session is going to be focusing on loss, definitely. But then, I want everyone to make use of this opportunity, especially this digital art. This is new, even I don't know anything, but I encourage everyone to pick up a new area which is upcoming, like digital art valuation, or for that matter, carbon credit evaluation. Yes, there are experts who have built, who are renowned in this areas, but we may or may not be able to approach them. But how much will be their charges? But whether this company will be able to pay them or not. But our scientific research, like how sir said, 1 week, maybe 1 week, 10 days time. I encourage Ravi Shankar Devarakonda sir to put his thoughts on a blog or take one separate session or post it on LinkedIn so that, he may get many more opportunities in future. He could be sought after, art valuer. I'm just trying to share that, with the social media coming up, we have a wide opportunity to showcase our talent, our thoughts, our articles. So maybe next time, whenever searching, anyone is searching on this topic, our name will pop up, especially
Yeah.
this carbon credit. Yeah, please, this session objective is that if I can inspire any of you, or, couple of you, or each one of you, I have done justice to my opportunity given by BVA.
Wonderful, wonderful, Shilpa. You have brought out so nicely traditional avenues of valuation and also latest ones. Too good. Let me share here something. Let me tell you that I'm an arbitrator with both domestic as well as international arbitral institutions. So, especially abroad, there is a lot of what should I say, importance given to quantum calculation, especially in infrastructure disputes or in construction disputes. So everywhere the valuers are respected and the valuers appear before the arbitral tribunal as an expert, and they give their written report, and also sometimes they appear as a witness, and they are also subject to examination and also cross-examination. So this is an emerging field of practice, which I hope some of the valuers may have availed it or maybe practicing. I just want to know, because in India, the importance given to valuation, especially in arbitration cases before the arbitral tribunal, have not come to my notice. Anyone,
Sir,
can you just share? Yeah, please.
sir, arbitration mein we have done valuation of the arbitration cases where they
Uh-huh.
wanted for the road projects, road and the toll projects. So
Wonderful. Wonderful.
specifically, sometimes they tell us that you value based on TCF method, or they say you value based on the comparable or the expected revenue method or existing method. So couple of valuations we have done based on where we have to do a examination, we have to see all the reports, the cross examinations, and what stage the arbitration is before arriving at a value. Because arbitrators
Wonderful.
themselves have appointed us for valuing so that he can give a proper judgment and a fair judgment, and even that will
Wonderful.
benefit the banks when they want to sell the entire fee to an ARC or to a national bank. So 4 or 5 cases, so the NABARD has the banks had appointed us because they wanted to sell the assets to the national bank, NABARD.
Wonderful. That means the tribunal has appointed you as a valuer.
Yeah, so banks had interested us, IDBI Bank, Bank of India, and ICICI Bank for valuing of the toll assets, because they
So
wanted to
nice.
sell off the assets, the particular arbitration matter itself to the bad bank and the RCL for the purpose,
Yeah.
asset reconstruction
Very nice.
companies. Yeah,
Oh, okay,
but
sir.
it's a very
Sir, you are,
challenge because it's a unique
yeah, it
thing
is.
to very. Yeah,
What are you an SFL valuer or
yeah.
plant and
No,
build?
I'm a SFA valuer, but when you have to value plant and machinery or other assets in that, we take the help of the asset valuer also. Sorry.
Yeah, yeah. Because this being construction disputes, so you need to have expertise of some civil
Yeah,
engineering
yeah.
or architecture.
Sir,
Mhm.
sir, we are a
Ah,
RV entity, so my partner is land building and plant and machinery valuer. So we are able to give
wonderful,
a
wonderful.
consolidated report on that. Yeah,
So nice, so nice. Anyhow, next time any opportunity is there, I'll contact you, sir.
sure, sure. Thank you, sir. Thank you very much,
Because
sir.
being I myself being an arbitral tribunal, this type of
Uh,
cases come to us.
yeah. But sir, the challenge
Thank you.
is how do
Thank
you value the this major thing is the damages and the penalties, because
you.
generally
Yeah,
the courts are not in favor of giving the higher valuation for as far as penalties and loss of profits are concerned. Because those are very subjective matters.
Very true, but it has to be brought out clearly because damages are running into thousands of, or should I say, millions of dollars sometimes, and sometimes liquidated damages. There is huge amount of confusion on liquidated damages and penalties. So one has to be an expert in the construction field also, and then give a proper, what should I say? They will be questioning you as to why did you adopt this risk-free rate of 7% or 3%. All the questions will come. Anyhow, we should have readily available answer to justify the DCF techniques, whatever we have adopted or whatever method we have adopted.
Yes, sir. That's a good thing. Thank you, sir.
So,
but we do take the help of the legal precedents. We do go through the case laws also where there are decisions based on loss of profit on the damages, and then we try to arrive at a judgment on that. Yeah.
Very right. Very right. Thank you.
The valuation principles remain the same, the approaches, everything remains the same. But the facts, how we are going to justify the whatever we are trying to say in our valuation report, yes, we can rely on expert, we can rely on whatever methodologies, but then it has to be supported by facts. And with this, I want to move on. And I take this opportunity to invite all of you, whoever have shared their thoughts, please contribute to our e-newsletter. Our president, Mr. Neeraj Agarwal, has started a great initiative of e-newsletter. So please contribute to the articles, especially whenever you have done any such new things, please share with us. And maybe you never know who will approach you again for a similar kind of valuation, since you are seen as an expert now.
Hello. Hello.
Yes, Mr. Ravichandran, you would like to share something?
Yes, madam. I think another possibility or opportunity you have triggered is basically one relating to valuation of Kaji sir ne jaisa bola, but basically to value the claims in infrastructure projects, because I have just come across a case that was dating back to 2006-7, one of the largest groups based out of Telangana, Hyderabad to be precise. I don't want to name the group because I was interacting with their one of the contractors' head there. He was basically a civil engineer, and they had done some work in Hong Kong. And as a result of which there were issues, that is a China-based company, and then the clients did not pay an overrun cost about $13.5 million. And subsequently, this gentleman put everything and documentation on the table before the arbitrator, I think in Hong Kong or Singapore, I don't exactly remember. And he got the complete award in that case in his favor. So as a result of which happened, he did the valuation completely for their claims. So claims is one possible area, and that's not a small amount, 13.5 million US. Just wanted to add.
Yes. Litigation and the claims or the damages, I think that's a wonderful area of practice. And, I think that time no one can say we are not, it's a right area for our practice. That definitely is an upcoming area. And I'll just start now. See, we are
one sec, Shilpa. Since Mr. Ravichandran has mentioned about claims valuation, let me tell you, just day before yesterday, I had one arbitration hearing wherein I asked not only the claimant but also the respondent, because respondent also put up a counterclaim. But however, they gave some figures, zigzag figures. I said no. Get it valued and give a certificate, approved certificate, and then undertake valuation of both claims as well as counterclaims. So that is another area of practice. And also, of course, insurance valuation is also there, insurance claims also. Probably that also area we can cover. Thank you, Shilpa. Thank you.
Yeah. Many areas are there. We just have to step into, venture out and do some research before stepping into these areas. But for now...
the claims valuation, any method is adopted or it's based on the agreement?
How much I can claim? How much can I claim? Basing is on whatever losses.
Based on the
agreement clause. Agreement is the base.
Shilpa, not only that, but you'll also have to see what is the documentation that has been entered into, and extension letters and the counterclaims as to whose default it is. So whether you may have a right in the agreement, but whether you have complied with all the conditions that are required to be able to claim that. But if there's a fault on your side and then you put a claim, it becomes a frivolous claim. So you have to differentiate between a genuine claim and a frivolous claim, and then come to a conclusion. So that's a challenge.
Yeah, and more so, we have to generate that what is the stop loss arrangement, whatever we have done, whether we have communicated properly, whether we have taken proper steps or not to safeguard at least to the extent, damage is controlled, all that definitely comes. That's more of a contract law. But now we'll move towards, the fact that valuers are not just number crunchers. We have to step into the role of strategic advisory as well. All of us know that, we are expert with respect to startup valuation, pitch deck, financial modeling. As a registered valuer, we cannot do all of this, but I'm exploring a new opportunity of advisory to startup, especially with respect to negotiation. Also, we are better off when compared to negotiating other than technical things with a prospective investor, and to discuss on the pitch deck, financial modeling, the nuances, the assumptions. If anyone challenges the foundation or the assumptions of the financial modeling, we are a best person to justify the assumptions involved in this. So moving on again from the advisory role, today's session is going to be a bird's eye view on all this regulations, SEBI, FEMA, and all of that. Let's start. The SEBI InvIT, thankfully one of the other professional, I heard that, he was talking about infrastructure and there was a claim and all of that. But right now we are restricting our session to this SEBI InvIT regulations. Under InvIT regulations, any InvIT, okay, let me also give introduction about InvIT. InvIT is nothing but it's a mutual fund for infrastructure projects. InvIT pools money from institutional investors. It could be pension funds, insurance companies, retail investors like you and me. And yes, they will have access to the infrastructural assets. The investors, as you all know, will not own these assets, but then they will have to buy the units of the InvIT, like how we buy units of mutual fund. And this InvIT will pool all the money and invest into infrastructure projects. It can be either to own, construct, build the infrastructure projects, or to buy a ready-made infrastructure project and then to operate, run, manage, and distribute the revenue. It could be, in terms of lease rentals or usage rights, or it could be toll collection in case of a highway project, so on and so forth. So in this kind of InvIT, a full-fledged valuation is required every year, say as of 31st March. Definitely, this is mandatory. And the entity has got 2 months time to submit to conduct the valuation, and only registered valuer SFA is eligible to do this. And every half year, it is also required when there are any changes in the valuation of the InvIT assets. And in case, again, there is a new terminology, borrowings and all, we call it as trust loans or term loans here. Whenever InvIT is not in a position to carry on the project with the investors' funds, it is eligible to borrow. And depending upon the borrowing percentage, we have in InvIT assets 100 rupees. Out of that, we will see what is the borrowings, less than 49%. Then we have quarterly valuation as well. And in case it is more than 49%, more than 49%, it's quarterly, less than 49%, half yearly. And I just want to highlight the SEBI InvIT regulations as well. But here also, yeah, SEBI InvIT regulations. I'll just focus on the main the InvIT regulations specifically highlight the rights and responsibilities of the valuer, like say whatever we have in this valuation syllabus, that we have to be impartial, no conflict of interest, all that they have really highlighted here. And as a valuer, we have to ensure that internal controls are there, and the integrity, like, all this normal declarations we have to make, adequate experience should be there, qualification should be there. But somewhere in this InvIT regulations, I have also seen that 5 years experience is required. So now, if I'm not eligible to give because it says 5 years experience, now then how will I gain experience if I cannot issue? So either we can collaborate, as I said, research, and then how we are showcasing our talent. This comes a really long way. Suppose today I'm signing a report, how can I show that I'm experienced without signing it? So there comes the catch, which I have already shared in the introduction. And due diligence, independence, all this is very much highlighted. And I'll just move to the real portion. This regulation, actually this is regulation 21, I think, which is, yeah, regulation 21, valuation of assets. The valuer shall not be an associate of the sponsor. This again is a specific thing. Full valuation report shall include the mandatory minimum disclosures as specified in Schedule 5. Yes, we will go to Schedule 5. And again, whenever any valuation report is issued, within 15 days, the InvIT has to disclose to the stock exchanges. Whenever any public offer, anything is happening, that again valuation is mandatory. And whenever there is any purchase or sale of the project as such, again valuation report is mandatory. And again, this is a nice thing, you know. Sometimes we see that we may or may not get an opportunity, but here, like rotation of auditors, now secretarial audit rotation has come. Now rotation of statutory auditor was always there. So now rotation of valuers also has started to start with SEBI InvIT regulations, and there has to be a holiday period of 2 years. So I see an opportunity here as well. Any material development is there in the InvIT asset, then within 2 months, again, one more valuation is there. And this, as I said, you know, we are not going to nitty-gritties, but yes, I will try to touch upon and give a bird's eye view of the opportunities available. And these are the mandatory disclosure.
Valuation under this InvIT regulations?
Sorry, Kushbu?
Have you issued report under this InvIT regulations?
I don't have 5 years experience. Now I have to start building it.
Okay, they are asking for 5 years experience as well. Where?
In, you know, valuing infrastructure assets. Somewhere in between they have written that. 1 minute.
So if we don't start, how we will have experience?
That's what I said, you know, we have to.
Obviously.
We have to collaborate with someone. Yeah. This is, no, this is different. One minute. Sorry, I'm not able to get this. But somewhere I have read that, you know, you should have enough experience also to value the infrastructure assets.
It must be in between lines.
I think it is the first 1 or 2 actually. I just saw that. You can go up and try again 5.
Okay, 1 minute. Actually, this is different. This is for the investment manager.
1 minute. Just go down. Next section. Next. You jumped out of it.
Okay, here.
No. Just.
Acha, before one. Again, here it is the investment manager.
Here.
We are talking about the investment manager who is different. That also I will come there. Or maybe it's not there, so I'm happy. Here. The valuer shall not be an associate, sponsor, investment manager, or trustee, and shall not. This is the catch. So experience doesn't mean actually signing it. It's about collaboration. It's about knowing the knowledge, like how this is a baby step, like how I have ventured into this, how I did a lot of, you know, research into understanding this. Okay, this could be, I can say, first step. Then I start a blog. Then I, you know, put some thoughts. Then I take separate valuation session to BVA members on SEBI InvIT. So this is, I can say digital traces of showing that yes, I'm experienced in valuing infrastructure assets. Yeah, but if you see this mandatory minimum disclosures, these are all very, very basic. This details of the project, latest pictures of the project, date of inspection, all of this is mandatory, you know, disclosures. So whenever any checklist is given, I'm sure, you know, all of the valuers will be happy to, you know, cover all of this. But I would also like to show one valuation report. See, as you see, the valuation of this entity is Intelligent Supply Chain Infrastructure Trust. Okay. This is an InvIT, just, you know, this was recent, so I chose this. No specific reason, I'm nowhere associated with this. And this is just purely my thoughts. The valuation date is 31st March 2025, and they had actually 2 months time. Sorry, that is just a reporting. This is the signing date. May 22, 2025. So the valuer has 2 months to give his report. And after the signing of the report, the trust has 15 days time to submit this. This particular day, this particular scenario, they have implemented the same day. And again, this has to be uploaded on the website of the company. And also this has to be disclosed in the annual report of the company. Here the trustee is a person who is managing the funds of the trust, and the investment manager takes the financial decisions of the trust. And the sponsor, just highlighting some options, the sponsor is a person who creates the trust, okay, and ensures that all the responsibilities are assigned. Who is the investment manager? Who is the trustee? All of this, and the registered valuer has to give to the investment manager who will be representing the trust and to the trust itself. And yes, we are expected to give enterprise value. And as I have already stated, the independence and all of that, we have to specifically mention that we are eligible. We hereby confirm and declare all of this. And just now, whatever we have read, regulation 13 and 21, we have to give a declaration. And as generally any other valuation, this valuation also, we can't either have a past interest in the InvIT or take a future interest in the InvIT assets. And suppose this InvIT is buying or taking up any other project, we can't be associated in the deal assets, because that way will become a conflict of interest. I'll just, they have done a lot of research. I must admit, the BDO is the registered valuer here. I don't know if any BDO valuer has actually participated in today's session, but I must admit they have done very good research. I appeal to all of you, keep doing research and all this SEBI related regulation related valuation reports. There we get a lot of research, these things which could help us in our own research. It could be like beta, it could be discount, just as a, pure, what do I say, research tool, I can say.
This report is available on internet video.
Yes.
This report.
Yes.
Wonderful. Too good.
Yeah. Basically, I'm seeing this as an opportunity to understand in such a big project, how are they taking valuation assumptions? It could be beta, it could be WACC, it could be discount rate, it could be the horizon period. In this case, I think some 20 years they have taken the future cash, that future projections. And that's a very detailed report. If you can see 44-page report, most of it is based on research, the industry research, the company.
The infrastructure projects are like, they are always for 20 years, like in the preference share. Yes. Also, it is given that for that, maybe they are relating to that and they are extending to 20 years. It's very good that practically they are doing this.
Yes. In that scenario.
Please share this report.
Yes, Shali. And having said this, when you're taking such a higher, forecast area, just in case our discount rate, I feel in this case, the discount rate could be a sensitivity, sensitive assumption, because the moment you change 1% of discount rate here, there, the valuation is going to be extremely, varying. So, and definitely SEBI stock exchanges and so many, I think some 5,000 crores was the enterprise valuation. So, you can understand the stake involved. So this is really interesting report which I have studied. And these are the basics, like you examine each and every method and then finally say, yes, this is the value of the asset. And whenever we talk about enterprise valuation, we should also understand the the term loan, what I said, whenever any borrowings are taken. So that value should be taken out and then the equity valuation has to be arrived at. That is a summary of this valuation report. And so nice photographs also. So just to show that, all of this is extremely important for us as a valuer. In this case, actually, Reliance Retail was the sponsor. They set up this InvIT. And investment manager was Infinite India. The project manager who sees the daily operations of the project was Geo Infrastructure Management. And trustee in the beginning I have shown. And these InvITs are listed on stock exchange also. So this could also lead to, whatever valuation report is issued, maybe it could affect the market as well. So I'll just show one more report. As I have said, half-yearly report, I'll not go into much nitty-gritties in this. This is under Regulation 21. This is the highlight of SEBI InvIT Regulations, Regulation 21. This is a half-yearly report. Half-yearly report basically talks about the changes during the 6 months, not the full report. And just for InvIT, I could see many, such opportunities. Like, now this is only GR Galgalia. This is just a private company is being taken over, which is handling certain project. So again, registered value or SFA, like, until now we had a thought, whether we are eligible or not to do a specified area of valuation. Now I see specifically only we are eligible. No one else is, eligible. So we can start picking up things like, it's
all these are available in SEBI website or?
Yes, SEBI website it is available.
SEBI website
And
and
as I
also
told
on
you,
the
in the
BSc
website
on
also.
the and also BSc and NSC. If you see the listed NSC, listed InvIT and REIT, there you will get the valuation reports. They have to upload over there also.
Yes, and company's website also it is available.
Yeah, company's website also.
So this is so beautifully they have done year-wise some, still from 25 to 39 they have taken finance income, changes in financial assets, O&M, other income, working capital, tax, FCFF. I don't even know, sorry, what is CAF, WACC, then present value of free cash flows to the firm. Then they add this cash equivalents. Then we have this adjusted enterprise value is just but adjusting to the cash and cash equivalents. Then we have all these assumptions. Yeah, this I think is a standard thing we expect from I'm sure it's the right time. We just don't take one beta as beta and then unlever it, then relever it and take some cues from reports like this. And see, this actually, sometimes I feel in a startup valuation, we tend to overcome this factor. We just take one beta and we just mention the source of beta. But why we are taking that beta or why we are relying on that information, actually, maybe I have to start. I haven't actually, seen this area. That's why I really like this report. So very well done. Yeah.
Shilpa, any idea why these InvIT projects are mostly trusts? Or can we get some other ways also how we have to fair value the enterprise or something like that? What are the assets that we are actually valuing here?
It is basically in this particular scenario, there is an enterprise valuation also, as well as the equity. Enterprise value meaning whatever borrowed funds we have taken. Okay, the value as such of the entire InvIT, that is one calculation which they have arrived at as a value. Another thing is what is the share price or what gets listed, for buying, selling purpose. That is the investor's price. So we also have to arrive at the fair value of the equity unit holders, we can say, or the investors of this InvIT. Why a trust is chosen? Because this is how it is permitted for all mutual funds, and InvIT is basically a mutual fund.
Okay, thanks.
Sorry. Yeah, this mostly I have covered. Again, we'll come to REIT. REIT, I don't see any specific, as a registered valuer SFA category, we do not have any special, opportunity in this area because this is a land and building valuer. Most of the REIT assets are real estate. Same annual valuation, half yearly, whether any changes are there, any specific issues, same is applicable for REIT, but that is a land and building valuer area. And we'll now move on to the SEBI buyback of securities. Here, when I have gone through the listing regulation, SEBI buyback securities, there was no specific mention of any valuation, but there is a place where the listed company has to disclose in the explanatory statement when they are seeking the approval of the shareholders as to what is the justification to the buyback price, whatever it is issued. Because what happens is the moment this board meeting happens, which will consider the proposal of buyback, there itself there will be a lot of volatility. The moment you disclose the notice of the board meeting, that time itself there could be a high volatility in the market. So in case the company has to give a premium, if you are doing the same market price, then again no one will offer for buyback. So you have to offer premium so that people actually will not sell in the market and then actually come and offer for buyback. So that is also, I can say it's a niche area of valuation as to what should be the buyback price. The management will actually be interested to know. So it's purely optional and not mandatory at all. And in case of unlisted companies, we have seen many ROCs, sometimes if they are not okay with the buyback price, they have resubmitted the form. Actually, it is at the stage of SH10, SH11, when whole buyback process is totally wound up. That time they ask for valuation. So, but yes, if the company has taken valuation, they can submit. If not, they can say they have not submitted and try to convince the ROC with a clarification letter that buyback is not mandatory there also. And with respect to SEBI AIF, actually this is, I don't say it as an untapped area, but yes, it is possible. It is applicable. And 2012 only, I don't know exactly when this registered valuation started with respect to, SFA category. But yes, we are the only eligible person who can issue this valuation report under SEBI AIF. And while we are doing this valuation, we should also understand that, everything is in with respect to accounting standards. Accounting standards have to be followed.
This AIF valuation for trust, they have to take the valuation report, each half yearly report. On the funds have to trust, and funds AIF has to invest in other securities, other company assets. So we have to value that company, whether it is running, whether it is IBC. So by clubbing that, we get the fund valuation, and it's a very good prospect, and the fees is very high because 10-15 funds at least we have to do. So it's a very good area, and most of the AIF, like bearing some, there are some prescribed criteria. So most of the AIF have to do the valuation, and it's a very good area for. Thanks for highlighting these areas also.
Yes, actually, as Pushpa has rightly said, we can use the sum of parts method. Like each entity which the AIF has invested is an entity in itself. There, if it is an asset heavy, you can apply NAV. In case it's a listed security, sometimes AIF invested in listed also. There also we get, from the market, we get
in
the
some
prices.
entity is in IBC, so we have to take the value 0 also because it is in liquidation. We're not going to have anything. So it's very prudential, and as in IBC, as in AIF also, we have to give justification for each entity. That is very much required. Why we have taken the value.
Not only that, the AIF also mandates if there is a variation more than 33% or change of method, then you will have to explain why they will change the method from CCM to CTM or from PORI to other method. And secondly, you have to follow IPEV method now, which has been mandated by SEBI. So you can't do valuation based on IVS or this one. Specifically for SEBI AIF, you have to do IPEV method only. And any change, you have to quantify the change and explain why you change the methodology. So these two are important factors to be kept in mind when you are doing an AIF valuation.
Yes, sir.
What is IPEV?
International Private Equity Valuation Guidelines.
Okay.
These are more or less similarly to line with the IVSC, but you need to study that and you have to apply basically that principles for valuing of each of the portfolio investment. Yeah.
I think the VP Education, Mr. Ravichandran, I appeal that, you have enough number of topics for your future sessions. So, please, as you can see, there is a lot of demand. Actually, we had long back the SEBI AIF regulation, but then you can repeat it, in the near future because we see a lot of interest in, even I'm interested to know more in depth on this.
Saturation time for us doing the self-evaluation. We need more areas, and you and Subbarao sir has told us the untapped area. We can discuss each week new area. We can discuss also. It's very good thing you both. That's why I was like, I will attend this session. Something new.
Ravichandran sir, not only you got ideas about topics and you have the speakers also you have that.
That's what I
Yes,
wanted to
yes.
say. Actually, you have told. Just I wanted to say.
Yes.
We have speakers also.
Yes.
Shilpa,
Yes,
let me
yeah.
just add here.
Sorry, sir.
Shilpa, can I add something?
Yes, sir, please, please.
The thing is, let me tell you, as an arbitrator, there was a case before me of an AIF where the investment manager did something wrong, and then the investor who had some percentage, hardly 2-3% of the 250 crores value of the complete AIF. So he had to lodge a complaint, and then finally the matter came up to us. Then I find that the AIF has undertake valuation. And then I asked for the valuation report, and then they submitted. I find that the valuation is done by a foreign company, some foreigner valuation. But he applied some standards which were not IBS, what Mr. Dharmesh Trivedi was telling, IPB standards, something. So for the first time, I came
Yes,
to
sir,
know
I'm
that.
listening.
Yeah, the first time I came to know that those standards
Hello?
have been. Can you hear me? So those standards they have applied.
Yes,
So
sir,
those
I'm
people
listening.
those people have got this valuation done by foreign companies. Are they valid to carry on this type of foreign companies can do it? Can be
No,
being in
no,
India?
they cannot do it. They cannot do it, but only thing what they do the preparatory work, and then they have some few registered valuer on their panel from whom they get the stamping done.
No. They submitted to the original given by the foreign company. I was wondering whether it was.
Sir, which year it was? Which year it was? Because after March 24, they cannot do it. Before March 24, they were allowed to do it.
It must be around that time only. I
Yes,
exactly
yes.
don't remember.
Now,
Yeah,
though,
so
it is
before
very
that,
much only the SFA valuer is eligible to do AIF
yes.
valuation.
Yeah.
Okay.
So after 31st March, SEBI circular is very clear. After 31st March 2024, everything has to be done by IBB registered valuer only.
It must be
Yes.
Yeah, so nice. Thank you.
Normally, it is 6 months, but then if the investors agree,
Yeah.
special resolution kind of a thing, it can be made, it can be changed.
Yeah.
We'll move to SEBI share-based employee benefits and sweat equity regulations. Here again, specific recognition has been given to valuer. Not been given. I don't know, for some reason SEBI forgot or not. Still the old, chartered accountant, merchant banker is there. Maybe, we can suggest to SEBI, please, relook at these regulations. At least so much of research I did, I could not see the valuer definition changed in this particular regulation. But yes, going forward, we can see SEBI, amending it. But this sweat equity thing is what surprised me when I tried to search as to which listed companies have taken this route and then actually issued sweat equity shares to their promoters or employees, whoever. It was very, very hard for me, and because I was so curious to know, how a sweat equity valuation is done. Because I have done so much of, research on this, what is the right way? Actually, there is no specific one way to do sweat equity valuation. Each valuer has to decide on his own what is the right methodology. But we have, in this case, Sangam India Limited, only so much of research I could find only this. And here also, it's a very vague thing. The details, with respect to section 54 sweat equity shares, they have just spoken very, very generic in nature. But they have relied on this particular valuer. We are talking about the valuer, the particular promoter, and very, very just 6,25,000. Why? Again, it's based on the report of the valuer. Corporate professionals valuation services. This report is actually very confidential. This report, there is no specific requirement to upload it, so we are not able to get. But when I did research for my own case, I have done research with respect to, say, for example, market approach. If the promoter or an employee, say, for example, CFO, we want to issue sweat equity shares to CFO, wherein you cannot say there is an IP, there is a know-how, technical know-how, he has created a product because of which this is a value. We cannot specifically say that. So in this kind of scenario where there is no IP, there is no technical know-how. There is no software, something which is generated specifically attributable to that person. In that case, we can consider what is the market value of that person. Like in case he quits the job and goes to elsewhere, what kind of compensation is going to get, and now what the company is compensating him. But this is just one of the indicator. And how about we taking an employee, we as a company take an employment with his experience, and the amount we spend and the time we spend on training him. So for example, no one can be productive in the new office the day one. They take time to get to know about the company, about the people, about the product. Almost I can say 5 to 6 months is the lead time wherein a person can be expected to full-fledged give his services similar to the person who was continuing since many years. That could be one criteria. Another criteria could be like many other criteria. I'm not getting specifically. I can say how much he has contributed in terms of the new ideas or new branches, or what is the additional cash flow which we can expect because of the professional or an employee or a promoter like identified so and so. Again, the challenges will become very complex in case 2 or 3 people we want to give sweat equity, because suppose CFO, CEO and all, it's a combination, and how to justify each of the person's sweat equity is really challenging. But yes, it's an open area, no specific guidelines. The valuer has got a greater responsibility to share his thoughts. The consideration, if any, to be received for sweat equity, it's like, he has been there in the company for 17 years. So yes, we will move on to the next point. With respect to SEBI LODR, actually the time is very short. I'll be moving very fast on this point. Under SEBI LODR regulations, recently there has been this is very recent. It's actually not an untapped area as such. But yes, since it is recent, I will just try to share it with all of you. The stock exchanges have issued this circular, wherein joint meaning both BSE and NSE. This circular is highlighting and consolidating all, whenever any listed companies are undergoing a process of scheme of arrangement. It could be merger, amalgamation, whatever, blah, blah, blah. We'll see slightly next. This standard operating process has to be followed. This is more useful for a person who is handling any scheme of arrangement for a listed company. But we as a valuers, we have this, master circular. There is no change as such in the circular, but a consolidation of all the circulars what we have. And now this is just a checklist purely for those who want to practice in this area. This is purely a checklist which beautifully,
Can you share all these checklists at least?
But actually too many things are there. I don't know if you would like to DM me for any specific things, because it will be like spamming the BVA WhatsApp group with so many files. So I will
ask you for some of the things.
Yes, we will see how we can share all of this. This is rather old. That's what I said. This is not a new area. But then yes, taking this opportunity and cue to share with all of you.
These files may be shared. All these files may be shared via emails.
I will check with Vijay. Maybe we can drive an open link in Google Drive and share the link.
Yes,
so
that will be good.
Thank
you.
Yes, definitely. And we have a reference to this master circular on the scheme of arrangement with respect to SEBI, regulations. In this, there is a reference of, valuation report. Whenever there is any scheme of arrangement, the first thing will come is valuation report. Then audit committee. Audit committee also has to consider the valuation report. Then it goes to board. Then shareholders and all of this stuff.
So there are some private companies who are interested in takeover of another private company or another partnership. Will it?
Yes, sir. Under a simple merger, like when you approach, any scheme, we have to go through NCLT method. That time also valuation is mandatory, because that I see is a normal practice. This I saw, as an untapped, because normally we don't see SEBI or listed companies as such to take up this. I will share with you one very nice point. I'll just share with you in the next slides. As we can see, this is the specific point in the master circular clause number 4, which talks about the valuation report. And here registered valuer definitely is in SFA. And what is expected is they talk about Annex 2, but actually Annex 2 is not really detailed. I will quickly go there. And this also I will go. Valuation report is not required in cases where there is no change in the sharing. These two are my main focus areas now. And one more slide I will touch on NCDs and NCRPS. This is a non-convertible instrument. Still, you can say the valuation is required. Specifically, is there whenever there is any listing of NCDs or this non-convertible, valuation report is mandatory. I'm just highlighting the places where specifically this valuation, and I was so excited when I saw these regulations. I said, okay, Annex 2 they are telling valuation report is there. Let me see, like how in SEBI InvIT they had too many things. I was so happy when initially I read a reference, but then when I came to Annex 2, this much only. So whenever there is any SEBI related scheme of arrangement, they expect that each of these approaches to be followed. So this is one surprising thing I saw. Such a big listed company, and we are talking about a scheme of arrangement, and only this much is expected as per the regulations. I'll just scroll through fast. Yeah, this is what I want to highlight now. This is a scenario wherein valuation is not required. Suppose there is a demerger and there is no change in the shareholding pattern. So it can be something like same shareholders are there. We call it as mirror shareholding pattern. So whatever is the first entity as it exists now, and the new entity which we call it as resultant company, which is going to take care of the business which is hived off or demerged. It can be a branch or a division or a product which is getting separated from the main company, and then the new entity shareholders are same as the main, or that is also a change of no change in shareholding pattern. And another scenario is where there is a holding subsidiary company. The new demerged company is going to be a subsidiary of the main entity. That time also there is actually no change in the economic interest or beneficial interest or the change in the shareholders.
But just I would like to add here, we need to give some ratio, like, okay, for each 1 share, we are going to give 1 share, or for 10 shares, we are going to give 1 share. At least we need to give some valuation. But by disclosing that, there is no change in that. Depending upon the resulting company share capital, we can discuss with the management and we can say that.
Here, I can say, a registered value report is not required, but then, it's a call of the management whether to actually take or not. I will just share with you one. This is a case of, we have this graphite business, which is getting demerged. And there is also, after demerger, whatever is the balance entity, that entity is going to be merged with another entity. So this is a combination of demerger first and then a merger. And again, I can see some 40-page report here.
Yeah, even if you see it down, okay, they will mention that income approach or asset approach or market approach, it is all not applicable. But okay, for the sake of compliance purpose, okay, they want to get, okay, when you are allotting like 1 share or 2 shares, whatever it is, then at least they require that report.
Yes. So having said that, I can also take an interpretation that even though the valuation specifically in the SEBI master circular, it is very clear valuation report is not required. But when you say valuation report is not required, then, as Subbarao is telling, real valuation is not required, but we call it as, absolute valuation. Absolute valuation is the way we arrive at a particular business. What is the actual value? And relative valuation is about exchange ratio, entitlement ratio, all of this. So I personally feel that, even though the SEBI master circular is talking about no valuation requirement, what they mean could be no real valuation is required. Because otherwise the whole scheme, who is going to tell how many shares one particular the parent company or the first company will give how many shares, of the new entity which is coming. So definitely, I take the cue from Subbarao and say, not literal sense, maybe valuation report is not required, but yes, with respect to valuation methodologies. Here, they have specifically taken, graphite business is getting demerged in this scenario, and they have specifically used all the methodologies, given a weightage and then given a value per share. But with respect to demerger, this valuation is not used. They are doing it just to help the merger of the balance business with the other entity. I will also highlight this. With respect to demerger, I feel what Subbarao is trying to tell, that's an area which definitely each one of us can try to do, because it's very, very simple. You just have to say that, no need of experience, no need to be big fours and all of that, but then do all of your research, all the analysis, fill the report with good number of pages, and then give this. We understand from the scheme that upon demerger of graphite business from HEG into resulting company, the management proposes to issue 1 equity share of HEG Graphite Limited to all the equity shareholders of HEG in lieu of 1 equity share. So it is 1:1 only. The proposed demerger shall entail allotment of equity shares of HEG Graphite to all the equity shareholders. All the equity shareholders we are giving on a proportionate basis, and all equity shareholders of HEG shall be the beneficial economic interest owners of the resulting company. That is, shareholding pattern shall mirror. We believe that the proposed share entitlement ratio does not, whatever is proposed by the management 1:1, so it is not affecting anyone. So yes, but in case there is any change in the proportion, some shareholders are not willing to continue or any such scenarios, then definitely real valuation is required. So we'll quickly move on. Sorry, I'm crossing the time. We are talking about next is non-convertible securities. I don't have much time for all of this. But yes, sometimes we feel that, what is there to value in debt? Yes, there are, sorry, I'm really running out of time. All of this I'll be sharing. So please go through this, how, and wherever SEBI arrangement is there, and that NCDS and NCRPS is out. This again is a very surprising thing. I don't know if I can quickly share this. The ultimate conclusion here was each of the NCD holder, each of the redeemable preference shareholder will going to get the shares of the new resultant entities, terms and conditions, same number. That is a conclusion. Actually, I'm not able to go to the exact para, but this is the conclusion. And then they say there is no specific valuation, whatever is the exchange ratio provided to the management, it's correct. That's the final conclusion of this, NCD's valuation report, which I have covered. And this ICDR, actually, ICDR is not an untapped area at all. Like all the listed companies, if they go for preferential issue, we have this frequently, non-frequently traded and the recognized stock exchange. This is purely formula based. So, but then, still they have to take the valuation, because whatever is given under regulation 164 is only the floor price. So in case any specific method is given in the articles of association of that listed company, that also has to be taken. So the valuer, whatever he gives is, in case it is below the floor price, it could be questioned. But I suggest this floor price is mostly on this, 90 days volume weighted average price and 10 days. This, higher of this, and then all of this is a floor price. Again, the company is called to rely on the value and then proceed and go for preferential offer of shares. And in case of stressed asset also, there is a specific regulation. And under regulation 164B, there is, this I think, normally 164 is always seen, but maybe 164B could be misread. That is why I specifically highlighted. In case you are going for a preferential issue, whatever till now I have said under 164, floor price, how to calculate 90 days, 10 days, frequently traded, all of that, plus articles, plus valuer. And we also have an option of 12 weeks and 2 weeks. So this is again, between 12 weeks, 2 weeks, whichever is higher. And the company, listed company, has an option to go either with 164 or 164B. Again, in case of infrequently trading shares, it's again, I can say normal like an unlisted company, but then SEBI has listed out book value, comparable trading multiples and all other parameters to be verified by the this is something, in case of there is any takeover or any such thing, the person who is going to have control will have, the valuer has to mandatorily consider control premium. This is one thing which I thought I'll bring to everyone's attention. And there is one also reference of relevant date. Whatever is the relevant date considered by the valuer in all these ICDR regulations has to be very much close to the board meeting, because the date should not be earlier than 30 days from the shareholders board meeting. So for example, today is the shareholders meeting. my report relevant date should not have been, say, 8th of July. 8th of July 2025, or actually I can say 10th of July 2025. The 30 days have to be calculated, and my report cannot be earlier to that. Today, if it is the shareholders meeting date. These are some things. FEMA, again, I want to say that, this is not an untapped area at all, but just wanted to bring to your attention. All of us know Form FCTRS, Form FCGPR. And one thing what I would like to bring to your attention, that many times I tell many of my clients, I'm not a chartered accountant, I'm not a merchant banker, I'm not a cost accountant, so please don't use my report for FEMA. Still, many people have used my report. My report was not even mentioned that it can be used under FEMA, but then many times I've said, ma'am, your report is taken. I don't know how, RBI is not very particular about the qualification of the, value, or I don't know, but many of my clients have said, my report has been considered under FEMA FCGPR, not FCTRS, but FCGPR. I have got feedback from my, the companies to whom I have issued. Under ODI, this is a very much picking up area. This, I think, as such registered valuer, I can't say that, we are eligible. But yes, merchant banker, yes, definitely their valuation report is taken. Chartered accountant also, CPA also. But then again, it depends on case to case, depends upon the authorized dealer. So please, whenever you're taking up any FEMA ODI valuation report, please consult your authorized dealer. And after his, consent or whatever, please proceed for valuation. It shouldn't happen that I, as a capacity of registered value SFA, being company secretary, take up the entire valuation and then charge them, and everything is over, and then AD says, no, she is not eligible. So please take proper precautions and then take up this ODI. So we have come to the end of this session. Sorry for exceeding time. And I thank Bangalore Valuers Association for giving an opportunity to me to share my thoughts. Yes. Thanks all for a patient hearing.
Thank you, Shilpa ma'am, and Subbarao sir also for highlighting these areas. I am very happy that new areas and many others also have shared their views. We got the speakers. That's the good news for VP Education. But yes, you have highlighted many things, many valuation areas actually, which we can explore or we can read. And Subbarao sir also for clarifying on this conversion of loan when there is no agreement. These things are very helpful. Thank you on behalf of Bangalore Valuer Association, both of you. Thank you. And we have exceeded the time, but we are happy that we are learning at least. You two should take separate sessions, ma'am. 1 hour is not sufficient for you and for him. So this is just an honor on behalf of Bangalore Valuer Association. This is the memento we give to our speakers. Thank you, both of you.
Thank you, Kushbu. Thank you very much. And also, as we discussed it today, okay, we have many untapped areas, okay, like ART valuation and other REET valuation, AF valuation. Maybe in future, okay, we can have further discussion, okay, like 1 day discussion, like 2 hours discussion on each topic. It will be beneficial to all the valuers.
Now, we should also urge members who have joined today also to come for our 2-day workshop, which is physical workshop. And Dharmesh and Kazi sir, I request you also, you two are very I am happy to listen you for the first time, and Ravi sir also, he has contributed to today too. I want to meet you all. Just please come for the 2-day workshop.
Yeah, great.
Waiting to meet you also.
Yeah, we would like to see everyone on 22nd and 23rd.
Yes.
Thank you all. Thank you all.
Thank you all. Thank you, BVA, once again.
What is a small suggestion? In case the time permits on 22nd or 23rd, these opportunities may be covered in that session, at least briefly. This session is very, very useful and very enlightening.
We can add. Shilpa ma'am, we can see if
the schedule is packed with veteran speakers from the Big Fours, I think, Mr. Ravichandran.
If any, one hour, we have time, we can discuss that one at any issue.
Yes.
Okay. Thank you all. Have a happy weekend.
Thanks.
Have a happy Raksha Bandhan.
Thank you. Have a nice day.
Happy Raksha Bandhan also. Happy weekend. Thank you.
Thank you.
Stop the recording, Shilpa. Vijaya?
Yes, sir.